Welcome. This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you. You have a great program for you this afternoon, and I would hate to delay any further. Before we get started, my name is Katie Jones with ADR Services, Inc. I will be acting as MC this afternoon for this excellent panel entitled Strategy, Mediation versus Trial. I would love to introduce our program today. So moderating this interesting program is David Casselman. He is an ADR Services, Inc. mediator and arbitrator with 42 years of extensive trial experience representing both plaintiffs and defendants. Aside from his remarkable trial record, David was selected to be president of the Los Angeles chapter of ABOTA, the American Board of Trial Advocates, and recipient of their Lee Wenzel Civility Award, and a past president of CalABOTA, which includes all of the California ABOTA chapters. Thank you very much for moderating and putting together this program today, David.
My pleasure.
During his years of practice, Mr. Casselman had the privilege of litigating with some of the finest lawyers in the state. And having seen all of our panelists in action, he was able to reach out to the very best plaintiff and defense lawyers from north to south with expertise spanning across a remarkably broad spectrum of legal specialization. Starting on the plaintiff side, located in San Diego, please welcome Mr. Vincent Bartollota Jr. He is founder partner of the firm Thornses, Bartollota and McGuire, and has handled virtually every kind of business dispute, government tort, and condemnation matter, as well as a wide range of major personal injury cases. Mr. Bartollota has received countless verdicts leading to honors across the country, including selection as the CalABOTA Trial Lawyer of the Year. Thanks so much for joining us today.
Welcome.
Moving north to Los Angeles, please also welcome Mr. Bruce Broillet, also a renowned trial lawyer representing plaintiffs. His skill in the courtroom has earned him national recognition and respect among his peers, leading to his induction into the Consumer Attorneys of Los Angeles Hall of Fame and the Law Dragon Hall of Fame. Among his many honors, Mr. Broillet is a member of the Inner Circle of Advocates, composed of the top 100 plaintiff trial lawyers in America. Thank you so much for joining us, Bruce.
Thank you.
Now we have from San Francisco on the defense side, please welcome Mr. Peter Meier, a leader of the Paul Hastings Real Estate Litigation Practice and chair of their Financial Services Litigation Practice. He represents clients in real estate, lender liability, class action, bankruptcy, and mass tort litigation. Thanks so much for joining us, Peter. And finally, on the defense side from San Diego, please welcome Mr. Charles Grebing of the Wingert, Grebing, Brubaker, and Jusky firm. His expertise rounds out our panel of trial specialists, since Mr. Grebing is considered a giant in the field of legal malpractice and errors and omissions claims, involving lawyers, law firms, officers, directors, brokers, agents, architects, and engineers. So really running the gamut of expertise here. Thank you all for joining us. And without any further ado, I hand it over to you, David.
Thank you. And thanks to my amazing panel. Thank you for making the time. I know it's not easy. And I hope today we can cover some exciting ground, and thank you all for attending. I think we will touch on some topics that aren't usually covered in CLE sessions, and I'm anxious to get started. So the beginning point, I think, is for us to talk about when and how skilled lawyers start to prepare their cases for mediation and trial. We're looking at the question, is it the same? Are there real distinct differences? And I think there are differences between plaintiffs and defense. So let's start with the plaintiffs, because that's where the cases begin. Bruce, Vince, as plaintiff's counsel, you get a chance to choose your cases almost always, not every case, but almost always. And that's a distinction worth talking about. So at that point, where you're thinking about taking a case, Is the subject of mediation or potentially trial already on your radar, or is it too far in the future? Who'd like to go first?
Go
ahead, Vince.
Thank you.
I think we lost your picture.
Trial is always on your mind, regardless. So the answer to your question is kind of yes and no. When I'm first meeting that client and making a decision whether or not to take the case, sure, trial's always in the back of my mind. Mediation comes after that. But my first thoughts are, one, is this at least arguably this case have liability, causation, and damages, so there's even something there. But for me, the couple really important things are, one, is the plaintiff who wants me to take their case likable? I think that's very important for a jury. And the second thing is, what kind of story can I tell? What will I be able to put across to a jury to compel them to want to vote for my client? And that's kind of where the thing starts, right from the basic beginning. Is this person likable? And they have a good story.
And are those things that apply equally to mediation and trial?
Well, sure, but when I'm first getting a case, I'm always thinking this is going to go to trial. Mediation will develop as we go along in the case.
Bruce?
Yeah, and I am very much like Vince. From the very beginning, from the very first interview, I'm thinking about my closing argument in the trial. I take every case under the assumption that it will go to trial. I ask myself, Bruce, do you want to be standing up in front of a jury someday talking about this case? And if you're not feeling good about that, then you got to reconsider whether you're going to take the case. So right from the get-go, I am thinking about my closing argument, and that's informing my decision. The second point is very much like what Vince said, the likability of the plaintiff. I believed for many years that the most important person in the courtroom is the plaintiff. It's not the lawyers, it's not the judge, in terms of persuasion, it's the plaintiff. So if you have a likable plaintiff, that can really help you to get the jury to identify with them. But if you don't, whatever your facts are, you are building ramparts in front of you that you've got to get over in order to get the jury persuaded. So likability for sure, but also thinking about that closing argument right from the get-go and all the way through.
So Charlie and Peter, you usually do not have the luxury of picking your cases. You are assigned cases, generally speaking, although I'm sure there are exceptions. So what's the first thought in your mind at this point while you're getting ready to prepare? And is trial on your mind? Is mediation on your mind? Or there are other things that are front and center?
I'd say yes and yes, David. The consequence of not being prepared once the case starts to prepare it for and be ready for trial can be disastrous if you're not looking at the ultimate result. In the kind of cases that I get generally, however, there may be issues that maybe dictate whether that case is going to be immediately considered one that has to go to mediation and or arbitration, because a lot of times in my world, you're dealing with issues concerning written agreements, whether it is the underlying transactional event, whether it's the underlying trial dealing with the handling for a client by the lawyer of a particular issue. Generally, it's going to be the subject of a written retainer agreement. Generally, there may be issues with respect to whether or not there's mandatory mediation provisions. Generally, there may be some questions with respect to whether there's an arbitration provision in that agreement. And so those all have to be looked at initially. It doesn't necessarily change the ultimate outcome in terms of what you're looking for when the case starts, but it may have an effect upon how quickly you have to move relative to being ready for some of those initial events with the background facts and information that come along with that file that you've been sent from someone to handle that particular insured's case.
Here.
So I would agree with Charlie. You do need to look to the ultimate event, which could be trial. We're all aware of the statistics, however, that the number of cases that actually go to trial is somewhere between 1% and 5%. So even though you do need to have trial in mind in almost every case at the outset, at the beginning of a case, I typically am thinking more about positioning the case and getting the case in the right posture for a settlement, a resolution that would be the best outcome for my client. Depends on the case, but in many cases that I litigate, which often can be commercial cases, a trial is a bad outcome for both sides. And instead, I'm mostly focused at the outset of the case on what are the key legal issues that need to be resolved, or are there key facts that need to be resolved, or an important deposition that needs to be taken, which once you're through those steps, the case may be in a position where a settlement may be possible. And then, of course, I'm also thinking about what is the right means to get to a settlement. Is it mediation or some other process? Typically, of course, you consider mediation at the forefront and plan for that really from the beginning, not necessarily the mediation provider or going to your favorite mediator, discussing that with the other side, but at least starting to think about the timing of mediation and the type of mediation process that will be needed.
So from the defense side, how important is the likability of your client in the early going?
To me, that goes to the assessment of the value of the case potentially and the risks of not resolving the case. And so you need to assess at the outset your weak points and be candid with your client and make sure you're getting the information you need as the defense attorney that will eventually come out in discovery and go to credibility, likability of the client, how they, it depends on the type of case, of course. But in a case where the personal and personality aspects of the client are paramount importance, yes, at the very outset, you want to think about who is the client, who are the witnesses who will need to be deposed, and if the case goes to trial, be your trial witnesses, and assess also, do the weaknesses there warrant an evaluation of the case, leading to an attempted settlement, as opposed to litigating it aggressively for trial.
And Charlie, your cases are often very focused on a professional who becomes a very key part. How do you look at that issue from the defense side?
I think Peter hit it on the head. It can be just as important on the defense side as both Bruce and Vince talked about it on the plaintiff side. Gathering initial information that you can pass on to the carrier and or to the client if uninsured with respect to the potential exposure in the case is in fact largely dependent upon the appearance that's going to be made by your client. Granted, the facts matter, but as Bruce said, it really does matter in the end what type of an appearance. Is there an honest appearing person? Is there a person who appears dedicated to the issue and something just went a different direction? It's one assessment to take into account. If you're faced with someone who makes a bad appearance, gives off an attitude of one not caring, it is a case that is destined for problems right from the beginning, and you hope to be able to take that into account as soon as possible.
By the way, David, can I follow up on that?
Please.
Those are really, really good points.
Please.
I once heard somebody say that a trial is nothing but a fight for credibility. And I mean, it's more than that, of course, but it's a really good point because jurors want to know who they can believe. And so one of the things that I think Vince and I are assessing in that whole likability thing is credibility. And one of the things that we're assessing when we take depositions of the defendant or defendants in advance of mediation and trial is, how credible is this person? And, Charlie and Peter are stuck with whoever those witnesses are. And so they have to assess it too. But fight for credibility, really important to be assessed leading up to that mediation.
Yeah, and it sounds like what you're all saying is that your client's impression on the jury is critically important and may well be, if not a factor in taking the case, certainly on the defense side, maybe a factor in deciding whether to settle later. So that could lead you to mediation where if your client was unassailable, you might want to go to trial instead. I'm hearing no's, no no's, so I'm taking that as yes.
Well, there are very few cases where you think your case is unassailable, your client's position is unassailable. But yes, you do have occasion with some cases And depending also on the relief that you're seeking. If you're seeking a relief that's kind of all or nothing, such as rescission of a contract based on fraud, you're going to have to go out and prove fraud, and the defendants will try to show that there was no reliance or no material facts and so on. But so it depends on the type of case. But from a defense mindset, yes, you are evaluating your client as part of your evaluation of the case overall, and your strategy for mediation and trial is impacted by how strong you think your case is.
Well, given the statistics and the likelihood that most cases are really going to settle, what is your overriding thought? I'm hearing, I think, all of you, that you take jury trial as the worst case assumption, which requires the most preparation. And then if something happens along the way to short circuit the process, so be it. But you don't assume early on that the case is going to do anything other than go the full distance. Is that an accurate approach?
Not in my case, David. First off, I don't look at trial as a worst case scenario. I like the trial of a lawsuit. I enjoy that.
In terms of preparation is what I'm talking about.
I understand, but I mean, I agree with what Peter said before. A proper settlement is good for everybody involved in the case. I agree with that. But with respect to taking on a case from the very beginning, I don't think I've ever thought about taking that case in any way other than this is going to go to trial. I'm going to prepare this case as though it's going to trial. And then good things seem to happen in the interim. But I couldn't counsel anyone to take a case and work it up as though it's going to settle, because there's usually some smart defense lawyers on the other side, and they'll figure out when you're not prepared, and it'll come back to bite you and your client in a big way.
Well, that's a better way of saying what I thought I was saying, but thank you for that. So what I'm trying to get to next is, I think, an important distinction, and that is, you start to prepare your case. You've now got it in your list of cases. You're doing the basics. At what point do you start to think about, what causes you to start to think about preparing this case for mediation, as opposed to just focusing on getting it to a jury trial, if that's its logical result?
Yeah, I think, David, right from the beginning, and by the way, Vince took the words right out of my mouth about worst case scenario. I was going to say the same thing. I mean, we are here to try cases, and that's what makes life exciting and challenging. And that's one reason that clients come to us. But I think the thing that I'm thinking from the beginning is, the client has not come to me for the purpose of a trial. They've come to me because they know that if it comes to that I know what I'm doing, and I've had some success doing it, and I can try and am willing to try the case. But the reason they come to us is to resolve a difficulty that's arisen in their lives. And therefore, to me, you're really thinking both issues, mediation and trial, right from the beginning, because if you can resolve their problem in a way that's adequate under the law and satisfactory to them, and they can move on with their lives, wonderful. That's what they're there for. They're not there to hear us make objections in a courtroom. But if it comes to that, we're ready to do it. So I would say, for me, it's right from the get-go. Both issues are sort of on the same track, mediation and trial.
Are there steps that you, in your mind, think are earmarked more for mediation than trial? I think we all know pretty much everything has to be done to be ready for trial. Are there things that you do because they're earmarked, in your view, to get the case in shape for mediation, as opposed to purely going to trial? And if so, when do those things start to happen?
Well, to answer your question, if I'm understanding it, David, it develops as the development in the discovery process goes on, and you're trying to get it ready for trial. You'll figure out and find at a time when the liability aspects, causation, and damages are starting to establish themselves. You know or understand that the defense has a good understanding of what your case is about, and that maybe they're in trouble. And then it kind of breeds on itself that you start to say, well, maybe this is ripe for mediation now. We've got it at a point where the defense has a sense that they're in trouble on this case and they'll be serious about trying to settle it. So I think it's all part of the process of getting to trial itself.
So I'm seeing nods from Bruce as well. So is it fair to say on the plaintiff side, you're just pushing forward towards trial, and if things start to develop that cause you to think a meaningful resolution of the case by settlement could become forefront in your future, that's when you start thinking about it?
Yeah, I mean, you know, there's too many scenarios to establish a basic rule on this. But for example, if I've got a really good piece of evidence that the defendant has not discovered and they want to go to mediation, do I want to drop that piece of evidence before the mediation? Or do I want to wait to drop it during the mediation? Or do I want to wait until after the mediation? I mean, there's so much, there's a psychology to the mediation, understanding your opponent, understanding the carrier, all of this. And so it's hard to say one size fits all. So I think that's sort of, maybe I'm agreeing with Vince there, that, you know, it develops. It's, you know, part of it is Kentucky windage, part of it is just smelling the room and feeling how your opponent is doing and how the depots are going before you can really decide what to do in what order. That was a long answer, sorry.
Not at all.
It's kind of like golf, you know, it's a feel thing, you know, you kind of get a feel for when it's right to move on.
And what about on the defense side? You guys have got a completely different set of clients and issues, which we're going to jump into in a second. But from the standpoint of thinking about when might it be right to start focusing on mediation, what are your triggers?
I can go first, Charlie. You know, it's obviously going to be case specific, but there are cases in which when you evaluate the claims that you're defending from the outset, you see a weak point in the plaintiff's claims that if you put enough pressure on that weak point, you may be able to put the case in a good position to resolve it sooner rather than later. And I'm really thinking more again about commercial type disputes that I often defend. An example was a case in which there was a claim for specific performance that had far more value to the plaintiff than its other causes of action, but that claim for specific performance was its weakest claim. And if, you know, in that case, we saw a basis to challenge it on a demur. We all know demurs are disfavored, but challenging that one claim at the outset put some pressure on the plaintiff. And I think the judge saw that and continued the hearing on the demur on his own to see if the case might resolve. And in fact, having that hanging out over the plaintiff encouraged them to go to mediation, and we resolved the case about a year ago with that motion, with that demur never resolved. And I'm convinced that we got the case settled for a lot less money on the defense side than we would have if we hadn't taken that tack. But we never would have filed that demur otherwise. And if we were thinking solely about trial, we certainly wouldn't have put the investment into preparing that demur.
Yeah, and summary judgments are similar to that very often. They're pressure tactics. Charlie?
Yeah, following on Peter, you're right. At the beginning of this, the effort is to try and get as much information with respect to the plaintiff's claim as soon as possible. In the legal mal arena, most times you have a lot of that from the underlying action in terms of what's already happened. Obviously, the complaint helps in terms of identifying specifically what allegedly was done wrong and what the consequence of it is in terms of whether or not a better result could have been obtained. So I think up front, you're trying to get all of that as quick as you can up front without necessarily an eye on whether it ought to be mediation or whether it ought to be trial. As said before, that will develop as some of this information comes in. Gathering information with respect to what witnesses will say, particularly those that are critical to the outcome of the case, in some cases, maybe the underlying client plaintiff, I think is important to have a handle on that before you decide whether or not this is something that you otherwise can approach in mediation and or trial. Again, assuming that you're not dealing with a mandatory or forced mediation or arbitration as part of written documents or agreements.
Right. So let's talk about the defense side, and in particular, the insurance issues. These are a fact of life in cases, and certainly in settlement, sometimes even in the trial of the case. How important is it from your perspective early on to understand either the coverage that's available as opposed to the risk you face, or maybe even recoverable assets that are beyond insurance? How do those issues play a part in your early thinking about getting ready for trial versus potentially settling a case?
Well, I'll take a stab at that on my side of it. Initially, of course, you're going to be provided information from the carrier, at least in my cases, as to what the coverage is or what is suspected to be. For purposes of your question, David, I'm assuming that on this aspect, you're not faced with a coverage determining event at the end of the trial. And so you're simply looking at it from the standpoint of what's otherwise available, what the potential exposure is, what the analysis is of the liability and causation issues, and then how that coverage fits relative to the ultimate damage claim that's being presented. And obviously, it's something that one has to keep an eye on and one has to be looking at generally. But until and unless such time as you've been able to get enough information, at least on my side, to a company representative, to somebody who wants to know whether or not that assessment of both liability and causation takes into account ultimate liability in the first place before they start looking at a damage claim, it's not always easy to determine from the beginning. Do you have to keep an eye on it? Absolutely. Does it mandate in some circumstances taking an early look at mediation? Maybe. But then also it's dependent also in the primary substance, it's dependent on whether or not there's really a claim that someone on my side is going to believe that there's exposure for that they have to deal with by way of an eventual claim and putting up some money to resolve the claim.
And it's not that often that in your situation, Charlie, you'll have a claim where the potential is greater than the coverage. Is that a fair statement?
Well, yes, that can happen. And yes, an eye on the ultimate potential exposure. But I want to emphasize that a lot of times the legal malpractice carriers, the LPL carriers, want to know if there's liability exposure in the first instance before they want you to look at where you're going in terms of that ultimate result, because they in turn are either reviewing for their purposes internally and or they're passing off that loss to others on a stacked or tiered coverage arrangement. And they want to make sure that if they spend monies, they're going to get them back based upon a reasonable and fair evaluation and assessment of what the underlying liability and damage claims are.
Right. So, Peter, you often are in situations where you don't have all that much insurance. It could be a corporation. It's got plenty of money, but insurance is only a portion of what's at risk. How does that play into it?
Yeah, it depends on the type of case. Sometimes insurance is just irrelevant depending on the claims. So, you do your diligence to make sure that, notice of any claim is sent out if there is insurance. But often it's not a major factor in your case strategy if it's, for example, of course, a fraud case. However, there are cases that I'm involved in where there's multiple parties, complex litigation, where at the outset you do need to do a lot of legwork on understanding the extent of insurance and coverage issues and share information informally under case management procedures. Ideally, you don't need formal discovery, but sometimes you do. But I've seen courts order in state court in California a disclosure of insurance information by a date certain, often tied to mediation proceedings that the court is aware are ongoing, so that there is an effort to get insurance information out to all the parties in a timely way so that it can be considered as part of the process of preparing for mediation. And even sharing under mediation privilege sometimes in information across parties and across defense groups in complex litigation about the availability of insurance. And further, and I know you've seen this too, David, I've even seen cases that are sufficiently complicated on the insurance side of them that a separate insurance mediator is appointed to address issues among carriers and defenses that they may have to coverage and issues that need to be resolved in order for the insurance funds to be available potentially if the case can be resolved with those funds. So in complex cases, it is important for that work to begin at the very outset, in my experience.
Yeah, and if you're dealing with two parallel tracks, one being insured and the other being, lack of a better word, out of the pocket of the defendant, whether it's a corporation or not, how does that play in terms of the settlement process? Do you find it easier or harder to get insurance money, or easier or harder to get the client to pay directly, assuming basically the same exposures in terms of liability, etc.?
Certainly there can be cases where there's a mix of causes of action, some of which would trigger coverage and some of which would trigger defenses to coverage, trigger exclusions to coverage. So that can get very complicated, and it's in those situations where mediation is your best tool if you're the defense lawyer to try to get to a resolution, because you can have the confidential communications that you need, on both sides, pressuring both of those potential sources for funding, including other defendants who you may have cross claims against or claims for indemnity against, which could implicate their insurance coverage as well. So yes, those are tricky situations, and you need to, in a mediation setting, it's a lot easier to push all the buttons that you need to apply the pressure that you need to bring to bear to raise the funds needed for a settlement. I'm thinking a little bit like a plaintiff lawyer in saying that too, but that's what you need to do sometimes in the complex cases, is think about all sources for funding a settlement, not just your own clients.
Right. So now we're getting into the weeds a little bit. Plaintiffs learn about coverage. That's part of the discovery process. And I assume it's very relevant to you guys to know how much is available the easy way, shall we say, as opposed to the hard way. And then the question is, do you use that information either as part of your mediation strategy or later? And for now, let's just talk about in preparation for mediation. How does the plaintiff effectively use what you know about the coverage issues, good or bad?
So if there's issues of coverage, a reservation of rights, something like that, you want to know that, and you want a mediator that is smart on that sort of stuff. So your selection of mediator is going to be affected by that. But particularly what I'm thinking about is if you have a tower of insurance. So let's say you have a $1 million SIR followed by $10 million first layer, and then a 10 million second layer, and a 10 million third. And supposing that your goal is to get the case resolved at 21 million, which would be the end of the second tower. So if you can get it into position where you can get the third layer in the tower with the opportunity to get out of the case paying nothing in exchange for the first two layers after the SIR putting up its money, then you get the case settled for 20 million. So I'm thinking about those breakpoints sometimes between the layers, assuming it's different carriers that have the different layers. I'm thinking about bringing pressure from up above, from the third $10 million layer onto the second, pushing them to make the deal and get this thing over with. And so you got to know that information ahead of time in order to know when and how to bring the pressure. Another factor is knowing who the carriers are. In injury and death cases, it's well known that there are certain carriers that, damn the torpedoes, they're going to take the case to trial. And so you have to recognize that and get your case ready for trial, and recognize that they're unlikely to get. Some of my best verdicts in my career, Vince may say the same thing, are cases where I was really trying to get the case settled and they refused to pay. And so they made me go to trial on a very tough case, and it worked out, and they ended up paying a lot at the end with the verdict. Vince, I'm sure you've had the same experience.
Yeah, That's absolutely right. Some of the big successes I've had are just because of the knuckleheads on the other side. that
Yeah,
refuse to
yeah,
settle.
none of which are on this webinar. But yeah, so knowing who the carriers are, you can tell which ones are more willing to be reasonable and really look at the evidence, and which ones don't care about it and you're just going to barrel forward and take their chances. Yeah.
Bruce, adding to what Bruce said, he's absolutely right. But I think the more common kinds of issues that come up with coverage that in more of the run-of-the-mill cases are the ones where you might not have enough coverage, and you're worried about it. Well, I got a case that I think is worth $200,000 or $500,000 or whatever, but there's only $100,000 worth of coverage. And so for the plaintiff side, we also are looking not just at coverage, but what's the wherewithal of the defendant, the individual defendant, and can we use that as pressure to get the carrier to pay up that coverage? And in many cases, we hope they continue to be obstinate and don't pay, so that we can open up that policy to get the full value of the case. So it's kind of two-pronged for the plaintiff side. We're looking not only at coverage, but we're looking at the individual defendant as well and what their wherewithal is.
Yeah, I want to talk a little bit about the whole issue of mediation confidentiality and the policy limits demands and things like that a little later, but it touches on what you were saying. And similarly, you have issues of exhaustion. You need to exhaust one policy and in order to get into the next one. And those are issues which I'm sure both sides experience, and they're also a headache for mediators. So those are important issues to consider, I'm sure. But at what point do you as plaintiffs try and raise this kind of an issue, whether it's any one of the issues we've just talked about related to coverage during the mediation? And the same is true for the defense. If you don't have a separate panel, which is rare, it happens, but you just have one mediator and you got a coverage issue or series of coverage issues, how do you deal with that with the mediator? Probably start with the plaintiffs.
You just come right up front with the mediator and say, look, when we start, we have serious issues here with coverage. I think your focus in this mediation has got to be to talk with those defense counsel and the various carriers, which we always hope have all shown up at the mediation. And you start there to get them off the dime on making sure the coverage is available.
Well, what about areas where there is no coverage and you know it, the defense knows it, and you've got a claim that bears on that? Do you lean into that to try and create pressure?
Well, the reality is, if there is no coverage and you find that out early on, and the defendant is impecunious and isn't going to be able to.
No, that's not what I'm referring to. That's a whole different problem. I'm saying there's money, but there are multiple causes of action. For example, as Peter alluded to, there might be an intentional claim, which is clearly not going to be insured. And then there are other claims that are insured. How do you deal with that in a mediation context? At trial, you've got your own separate issues, which we can talk about, but for mediation purposes, you're there. Those issues exist. Do you leverage them? Do you use a particular strategy, or do you just stay silent on those points?
Yeah, I hope that some kind of Kumis counsel or corporate lawyers or somebody have gotten involved and are bringing pressure on the carrier in the face of the reservation of rights or the coverage issues. The business, oftentimes has paid a lot of money for coverage over the course of time. And they now want the protection that they paid for. And so it becomes a business decision for the carrier sometimes to just go ahead and get the case settled. I don't know if that's what you're driving at, David. Everybody should know that David has tremendous experience both on the defense side and the plaintiff side, so he has seen it all. But I don't know if that's what you were driving at.
Well, I am, but I'm just thinking about the simplest scenario, and there are much more complex ones, but the simplest one being a fraud claim in conjunction with a variety of other run-of-the-mill tort claims. And everybody's going to accept the fact the fraud isn't going to be insured and that intent has to be proven. That's the good news, the bad news. But if you have a defendant, for example, that has assets and you're pursuing a fraud claim, not out of ignorance, but out of a desire to get to those assets, what do you do in the mediation to play up or down those issues? Because you got a group of insurers potentially in a tower arrangement or with the SIR, as you pointed out, that have to pay. And then there's this fraud claim hanging out there that's a completely different animal that doesn't even scare the insurance companies. They might want it to be a fraud claim. So from the plaintiff side, what's your pressure point, if any, in a situation like that? And just one example, there are many coverage defenses that you could be leveraging.
I think that Bruce answered the question. Basically, you try to focus on the covered claims and make them scary enough, for lack of a better word, so that then hopefully the defendant has Kumis counsel as well, can apply the necessary pressure to get the carriers to participate in the pay.
Right. But if there's no coverage, they're not going to have a Kumis counsel, likely. Depends, but let's talk a little bit about this from the defense side, because you see this more up close when you're in these cases, because you know exactly what's going on in terms of the coverage and you're sort of juggling. What are your thoughts about whether or not you should or shouldn't be playing into this or defending it in a unique way at a mediation as opposed to just dealing with the facts at trial?
Well, it can be a tricky issue. There's no question about it. If you are defending under a reservation of rights and there are covered claims and uncovered claims, you obviously want to stress the covered claims. And if you've got a claims representative sitting next to you in the mediation, you have to stress those covered claims and the issues with respect to the exposure and liability on the covered claims. It may not be such a simple issue as saying it's covered and not covered, because the facts are the facts. And a fraud claim bleeds into what otherwise might be considered conduct that is perhaps not totally meeting all standards of a fraud claim, but may impact substantially the question of whether or not a particular defendant has conducted themselves, for example, in some of my cases, in a manner that's consistent with the standard of care. And so I think you have to use what facts you can to stress that covered claim, downplay to the extent necessary the fraud claims, but not be ignorant of them or ignoring them from the standpoint of what ultimately the exposure in the case can be that some carrier is going to have to deal with down the line in terms of not having a clear result, at least from the verdict.
Right. So you're in mediation now, and let's sharpen the pencil a little. Now you're dealing with an outcome determinative reservation. So the classic 2860 Kumis situation, and perhaps Charlie, you can explain this a little more from the defense side. What are you thinking about there, and what does that mean to you? Why is it significant that they've declared this outcome determinative reservation?
Well, if the carrier has raised a coverage issue that is in fact outcome determinative to a non-covered claim, in other words, if there's any basis upon which defense counsel, at least as outlined under Civil Code Section 2860, has the ability to steer that result to a non-covered claim, then obviously a Kumis situation would arise. The case bothers me from the standpoint of whether or not there was ever an attempt to do that in the first place. But assuming for just a moment that you're sitting in that circumstance, I think you have to be extremely careful in terms of what can be shared with the mediator in a brief, whether or not any of that information is shared with opposing counsel in that brief, dealing with issues concerning the status of the Kumis counsel and or the claim. As you know, Kumis counsel do not have to necessarily abide by all issues with respect to a tripartite relationship if there had not been a coverage reservation raised by the carrier.
Can you explain what you mean by that for those who don't do insurance work on a regular basis? Tripartite relationship.
Well, The general case law has indicated that defense counsel is in a three-part relationship with its client, his or her client, and at the same point in time has confidentiality issues and fair reporting issues to the carrier in that same relationship. That issue in those circumstances, without a reservation of rights or something that otherwise might trigger a cumus setting, defense counsel it generally is required to, and in most cases reports all factual information to the carrier on liability, causation, and damages. If the tables are turned and cumus applies under the circumstances, or there are serious coverage issues that the carrier has made known, that tripartite relationship may not necessarily exist that would require the defense counsel to report everything and anything that might otherwise impact that coverage. And so it's a very careful path that has to be followed in terms of what you can put in the brief, what you can share with the mediator, and whether or not it's the kind of things that, separate and apart from the writing itself, you may want to share privately with a mediator that you trust to keep the information confidential to the extent necessary, maybe even require separate sessions away from the carrier representative in terms of explaining what those issues are and what they are not. But again, it mostly plays into, it's a tough road because most of it plays into the same set of facts that may determine a covered claim as compared to a non-covered claim, and the impact on each of those when you eventually get to a jury.
By the simplest example, the case of Gray versus Zurich, where there's a car accident, person gets out, somebody gets punched. And the question is, was the injury caused by a negligent act or an intentional act? Those facts have to be determined. And depending on how they're determined, the availability of coverage, the outcome of that question turns on that fact question. So that's the simplest example. They get much more complicated, but that's what you're referring to.
Yeah, that's in the setting of an intentional tort. That setting can come about as a result of sometimes a trickier issue. For example, what did the attorney insured know at a particular point in time prior to the time that they made the carrier aware of the claim? And are they facing a situation where they didn't disclose that information on either an application or on a renewal? That's really a tough line to walk in terms of what facts become available to the company that you're authorized to or not authorized to communicate.
So now you're talking about an attorney who's a defendant, and you guys have the plaintiff's case. And especially if there's cumus counsel, you know there's a real rift among the ranks. How does that play in terms of mediation? Obviously, at trial, the facts are the facts, but in mediation, how do you work that?
You know, I'm sorry, go ahead, Charlie.
No, please, that kind of is a plaintiff issue. And
Well, I mean, I was just thinking to myself that when those battles are going on the other side, I know I should make my demand as attractive as possible as an alternative to those battles. And I'm going to assume that the defense lawyers are saying to the client, to the carrier, whoever, these are smart plaintiff lawyers here. What if they drop the fraud claim and they put in a lot of the same evidence, but they don't make it a fraud claim and it becomes a negligence claim or whatever, a breach of contract or fiduciary duty or whatever? If they drop that fraud claim, you're going to pick up the whole thing that comes out of it. And so I'm just going to assume that the stuff that's going on in the other room in a challenging coverage situation is to my client's benefit, that those battles and that confusion and that uncertainty over things is going to help me get the case resolved for a reasonable sum as long as I stay reasonable.
So let's just focus for a second on when is a case ready for mediation. We've touched on a lot of various factors that cause us to turn in that direction, but from the standpoint of preparation, is a case that's fully ready for trial obviously it has to be ready for mediation, but what about the reverse? Does a case need to be fully ready for trial in order to be mediated?
To answer your question, David, I don't think so. I think once during the process of discovery and getting it ready for trial, that you realize that you've got a good position with respect to liability, causation, and damages. You've given enough information to the defendants that they're aware there are issues that cause them trouble, then I think you owe it to your client to try to see if you can get that resolved before having to spend even more money in doing the last things you would do to get ready for a trial. So
Right.
I think it develops on its own. And again, you're working in discovery with the defense lawyers on the other side. They'll know themselves from the status of the evidence when it's right.
So what you're saying really is you might mediate a case without all the information you'd like to have at trial, but if a case is fully ready for mediation, it's essentially ready to go to trial, is it not?
Close, but I wouldn't say necessarily ready for trial. There are a lot of cases that you can get resolved through mediation very early on. And you might do that as a tactical play in order to save the extra cost for those extra experts, or that last, what you put on for trial, you make the visuals and the videos and everything. So again, every case is dependent on its own facts, but I see an opportunity a lot of times to resolve a case long before it's fully ready for trial.
Right. That would be a mediation short of preparation for trial that is focused on an opportunity. But I think the point I'm getting at is to be fully ready on the merits to mediate a case, you really have to be ready to go to trial. You have to have all the facts, most of the witnesses, if not all of them, most of the evidence. Do you not feel that way?
No, I can't argue with that. And again, the premise that we started on is that you take this case with the intent to go to trial. And so you're working it up to go to trial, period.
Right. So now once the case is ready for mediation, whether it's early or later, based on the full gamut of the issues, do you sometimes have goals that are beyond just trying to reach a favorable settlement? And by that, I mean tactical goals that you have in mind. Not every mediation settles. Do you want to get something out of this that may be short of a settlement if you're unable to ultimately achieve that? What's your thinking about that, Bruce?
Yeah, I mean, I'm ears open at all times during the handling of a case. And even though the mediation privilege applies and I can't use the things in a courtroom that I am, well, I won't quite say that, but even though you've got to follow the mediation privilege, you're listening and learning a lot of stuff, and take advantage of that information as you continue with further discovery in the case. I listen, and also I'm trying to learn, for example, does it feel like the lawyer really wants to get the case settled, but the carrier is the reluctant one? Are there two leaders in the other room, one of whom is the damn the torpedoes person and the other one is reasonable? And can anything happen during the mediation that causes the damn the torpedoes person to lose credibility with the client? That they suggest a move during the mediation that doesn't work and suddenly they're no longer the key voice in the other room. I listen to everything I can hear.
Other thoughts?
I disagree. I mean, I agree with that, but I also make it a point I don't remember, other than a few exceptions, where in every mediation, I let my clients know right up front that, look, you're going to come, bring a book. It's going to be boring for you. Sit in, but you're going to be in another room. You're not going to be in the same room with me. I always want my clients in a different room. And I tell them the reason for that is that I want to learn as much as possible about the other side's case if in fact we're unable to settle it today. And the way I do that is by being alone, just the lawyers with the mediator, because a mediator, in my experience, has been far more guarded about what or how they say something when the clients are in the room at the same time. And I tell the client, look, I'll come in as soon as I talk to the judge, I'll come in and fill you in on everything. But it's important to us to learn as much as we can about the other side's case. And even more importantly, what this judge sees as weaknesses in ours. This judge may be hesitant to talk about weaknesses in front of you because he doesn't want to hurt your feelings. He's a human being too. And so I find that works very well for me.
How about the defense? Different, same?
I mean, similar thoughts, David. You know, what you're looking for, of course, is a good read on if you're on the defense, the plaintiff's, valuation of the case and the demand that they make, if they make one in the mediation, even though you assume there may be posturing and positioning going on, can be itself very useful information. If they're not there to waste your time and their time, they will take the process of negotiation seriously, and seeing where they start. If it starts with a plaintiff demand, it often tells you how the day will go, and where they are fairly evaluating their case. So, and then from there, the process, even if you're not in the same room with the other side, of supplying the mediator with the information you want them to use in discussing the case and the risks for the other side, and then hearing what they come back with as answers is valuable information, even if you don't get anywhere near a settlement in the mediation, or on day one of the settlement at least. You can get very, very useful information for the remainder of the case, not only on the merits issues, but also as you then strategize toward motion practice, and will there be a more opportune time to settle the case if it's not going to happen in that mediation session.
In a lot of mediations, mediators see posturing, a lot of posturing. How do you guys look at that? Is there a value to tough talk, or even the opposite, lulling the other side into complacency by just sort of laying down and not acting like you're prepared? Obviously, none of the people on this panel ever do that, but in general, do you use the mediation sometimes to posture?
So I can start on that. I'm going to answer the question of is tough talk, useful? I would say no. Your clients, typically, at least the clients I represent on the defense side, are sophisticated, and they've heard from a lot of tough talking lawyers before. What's useful is persuasive information delivered in a way that's credible, and that is thoughtful and anticipates the arguments that you will make against the case. And so if you can present the information in a way that shows that you have an understanding as the plaintiff of your burden of proof and the weaknesses in your argument, but nevertheless why you believe you would prevail, and the risks attendant for the defense side if you do prevail, if you present that way in a persuasive manner, and I don't think the style is to be overly combative or direct, but just persuasive, that can be very effective in a mediation session. I have seen an attorney kind of go into wild man mode, or light his hair on fire, and maybe go over the top. And I think that's off-putting. I think most of the sophisticated clients who I represent in mediation sessions, are put off by an overly aggressive style from the other side.
I have to second that in every respect. Plus, it also has the potential of actually denigrating the case of that particular attorney and the position that they're trying to take, and actually might cause a reverse action on behalf of the either defense attorney or opposing attorney, and or any carrier representative, and or any client that's sitting and listening to it, in terms of what you might expect that person to do in front of a jury. If they're going to act the same way, if they're going to take the same position, if they're not going to argue facts and law with respect to the viability of the claims, all the more reason to let them go ahead and get ready for and try that case.
How important is it to you to represent yourself in a way that impresses the mediator as distinguished from the other side?
Yes.
David, I think the entire issue of the question you just raised can be summed up in one word: credibility. It really, the practice of trial law is all about credibility. You may be in front of this mediator for the first time, or these defendants for the first time, but you may well be in front of them again in the future. And whether or not they pay attention to your cases depends on your credibility. And so I think that's key. And so I agree with everything that both Charles and Peter said. I think it's all about just letting the facts do the argument and the pounding on the table for your case.
So from the perspective of a mediator, after a lot of years talking to mediators, I have to totally agree. When the parties come in, they almost always sort themselves. You can tell that some people are being straight with you. Some people are being pedantic and sort of hyperbolic, and others are prepared and just talking about the real issues and conceding your weaknesses. At least from my perspective, I can't speak for all mediators, but conceding weaknesses that you know to exist adds to your credibility. It does not hurt you. It makes me at least believe that you're realistic. You understand what's happening, and it causes me, again, just can't speak for anyone else, to trust that I can believe what you're saying on other issues. So it's valuable. Let's talk a little bit about briefing. Mediation briefing, of course, is different than a trial brief, but how do you approach the mediation briefing process? There's the opportunity to keep them confidential. You can talk about whatever you do or don't want. How do you approach that issue?
I think it sort of varies from case to case. There are many cases where I want the mediation brief to be confidential, others where there are portions that I want to be confidential, and I make that known so that the other side maybe can receive the brief a week or two ahead of time and then be able to evaluate things better when they come to the mediation. I've even done cases where I have done a video presentation about both liability and damages, and then of course causation, and decided that I would provide that to the mediator and to the other side a couple of weeks ahead of time so that the decision makers can look and get a real picture of the problems that they have in the case. So it really varies from case to case and how amenable you think that carrier or carriers are going to be to settling the case as to what you provide to the other side. To me.
David, I agree with what Bruce just said, but for me, I approach every mediation with the idea that I'm going to try to settle the case. I owe that to my client. And so with that thought in mind, I put as much information as possible in that mediation brief, but don't misunderstand me. I'm not saying I put everything in it. I put everything in it that I think I need to get the message across to the defendants that they're in trouble and they should pay. If I have some smoking gun, I may not at all put that in the brief, figuring that I don't need it right now. If things seem to be progressing well during the mediation, then I may let the mediator have the smoking gun. Whether I tell him to use it or not, but he can tell them in the discussions, hey, look, he's shown me something that I think causes you a lot of heartburn. If we get down to the number that we're really close to getting it resolved, I may say, okay, you can show it to him. But again, I think the whole purpose of the mediation is to go with the idea you're going to settle it. And I think you need to give the other side as much information as possible to make them want to settle the case.
How often do you share information with the mediator that you don't want the other side to know?
That's like my comment before. It's like golf. It's a feel thing. If you feel you can really trust this mediator, that he'll keep the secret or keep it confidential, then I might tell him to make him work harder in the other room. But I let him know up front, look, I don't want you to disclose this. I'm counting on you not to disclose it, but I'm sharing it with you. So again, it depends on the mediator and your feel for that person as how they'll come across.
So those are the plaintiff's views. They have the burden of proof. How about the defense? What do you think about briefing mediations?
I generally put in pretty much everything that I think is relevant to the issues concerning the basic liability, causation, and damage issues, including information that might not necessarily be admissible, but with a warning that it's issues that may affect otherwise a determination as to the overall impression and value of a claim. I think sometimes in a mediation brief, it may be better to put in more than less. I totally agree with Vince that that doesn't mean necessarily everything. And again, it does depend on the, for lack of a better word, the ability of you to trust the mediator when you tell them something in confidence, that they'll maintain that confidence, at least for purposes of giving that mediator a chance to assess the value of the claim, the propriety of the actions and causes of action that are being presented, and come up with a good analysis and recommendation to the parties in terms of somebody needs to move here, and it looks to me like this side should or that side should. So I'm careful about what goes in it, but I err on the side of more information than less in that setting. I do have to agree with Bruce. I don't always share it. Many times it will be for the mediator's eyes only, and sometimes maybe a portion of a brief is written in such a way that it's then given to the other side, so they at least have some idea of where some of these issues are going. But again, it depends in large part on how much you trust the mediator.
Yeah, I would just add on that generally in my cases, I'm writing for the mediator in a mediation brief and not for the other side. I want to educate the mediator. I want to show the basis for the positions that we are taking, legal basis and factual basis in a persuasive document. And then it will depend on the type of case and the mediator as to how much information is shared in writing with the other side. With an active and engaged mediator, you can learn what the other side really needs to hear to change their position on an issue, and that may involve preparing a separate white paper or brief for the other side on that issue. But in a long-term mediation process in a complex case, I don't think you normally want to come out with all of your arguments in a full brief that the other side sees. You want to defer to the mediator and the process to determine what should be shared with the other side and when, in terms of your best arguments.
You know, it's funny, when you're the trial lawyer, I thought exactly like the four of you as the mediator. I want all the ammo. Give me all the ammo so I can use it. I don't want any secrets. Come on, help me settle this thing. Now, let's talk about a completely different topic. Focus groups, used often for preparation for trial, particularly in bigger cases. Anybody use focus groups to prepare for mediations?
Yes.
Yes.
How so?
Well, the focus group, we can fall in love with our cases, and we recognize that. So if we're going to be objective and see if we can get the case settled for the client, we have to get a good grasp on how other people, the type of people that are going to be on the jury, see the case. So not in all cases do I do a focus group before mediation, but if I think that it's appropriate, I might do one. I'm not going to tell the other side that I've done one or the results of it, because that's my information that I'm going to use ultimately probably at trial if it doesn't settle. But an important thing about the focus groups is I don't try to win the focus group. I try to learn from the focus group. So I will try the case hard. I'll leave out evidence that I think might not come in that helps me. I'll add in evidence that I think will hurt me, that I might be able to keep out, but I won't necessarily be able to. So I try it hard, not easy. And I'm trying it to find out what the energy in the case is. What are the potentials here? Is the basic storyline of the case one that's appealing to the kinds of people that will end up on my jury or not? And then I grind that in. And it's not often that I'll do a focus group in preparation for mediation, but sometimes I will.
Yeah. And I'm same situation. I think everything he said is spot on. You shouldn't, and I see this a lot or hear a lot from consultants who do the jury consulting stuff, they see so many lawyers, particularly young lawyers, that go in and try to win their case in the focus group, when really the whole idea is to find out what are the weaknesses in my case. What of my case is strong that I can sell and that will be acceptable to these people. And so, again, I agree with Bruce. You're more selective in doing focus group for a mediation than for a trial. But the whole purpose of that focus group is really to look at your case, what will win and what won't win. So you don't do it all the time.
By the way, David, one more point on this. People tend to think that a focus group should be about the whole case, but it can be about discrete issues. And so sometimes there's some particular point in the case that I'm thinking, this may not work, this may, how do I best frame this? What is the issue here? And so I might try a focus group, because sometimes we do more than one on a case. And I might try to tailor it a little bit more to a particular issue that I want to see how it works in the case. So it's just another, it just shows you the variety of ways that focus groups are used.
Right. So cognizant of time, let me skip into another area. This is the process of selecting a mediator. You've thought a lot about mediation going up to this point. So I take it picking the mediator is not the first thing you do in preparation for mediation. Does everybody agree on that?
Yeah.
That may be one of the last things you do. So what are you looking at when you pick a mediator? Are you trying to find somebody you like or somebody who likes you? Or are you looking at something else in this decision process? How does that?
From our standpoint, obviously, we would like to get somebody that we know or have had prior experiences with and like, but the reality is that that's useless if, in fact, the defendants don't have any respect for that mediator and are going to listen to that person. And so I look at a couple things. One, I want a mediator who has familiarity from trial experience with the subject matter. I think that's important. And then secondly, I want to make sure that that mediator is acceptable to the defense so that they will listen to what the person has to say. If not, you're wasting your time.
Everybody agree with that?
Absolutely. I'll add something else to that. On the plaintiff's side, we sometimes refer to some lawyers as defense lawyers as defending the Holy Grail. They never saw liability. They're going to fight everything tooth and nail. There are certain people that are like that, and God love them. They're warriors, and I respect them a great deal. But when they become mediators, that's not what I want. I want somebody that's seen it from both sides, that's rational and reasonable, that can recognize liability when it's sitting there staring them in the face. And they can recognize the risk of a case going to trial, even if liability isn't completely clear. So, you want to look for somebody that the other side will place some stock in, and that will not be, defaulting to what they were as lawyers.
David, I second that. I mean, to me, there's two words that come up, and it's credibility of the mediator and acceptability of the mediator. If you are picking someone strictly based upon what you think the outcome is going to be, because that person has tendencies to either favor the plaintiff and or the defendant, you're defeating the purpose. You're trying to get a good assessment of what the case is about and what the strengths and weaknesses of the case are. I don't use, going back a little bit, I don't use a focus group before mediation generally, unless the timing is such that it fits in with a trial. But the whole point of it is you're using, to some extent, the mediator as a member of a focus group that hopefully has had some experience in these areas, has heard both sides from an adversarial standpoint, not just you spouting off about what you think the evidence is to a one-sided approach. And with that, you need a mediator who's credible. And if the other side is willing to use somebody that they respect in the same fashion, you're ahead of the game. You have a better shot at resolving the matter based on that selection process.
You know, it's interesting. Peter, go ahead.
Well, I was just going to add, from a defense perspective, I agree with what's been said. The only thing I would add is, certainly as the defense lawyer, you do sometimes need to question, why someone is being put forward by the other side, and understand that many mediators do have a lot of history with certain plaintiffs' lawyers and firms, and there can be very qualified mediators capable of resolving a case despite that fact. But buyer beware when you're in that situation as the defense lawyer.
Yeah, I've heard it said, and I used to think this way as a lawyer, that I wanted to know who the other side wanted. And I was trying to find somebody acceptable from their list, not the reverse. And once they chose the person, I thought I had a better chance of talking to somebody with credibility in their eyes, which would give me a better chance of selling my case. But with that in
David,
mind,
I will add something to that. In a case of really good liability, reasonably good liability, which I see every once in a while. I see it a fair amount. So I don't mean to be self-deprecating there. I will sometimes tell my opponent, look, I know you really want to get this case settled. You tell me who you suggest, but make sure you don't load this thing in your favor, because if you do, the case is not going to settle and we're going to go to trial. So if you really want to get the case settled, and I know based on this evidence that you do, then bring somebody to the table that the carrier is going to listen to and who isn't going to torpedo everything we're saying. Somebody that's going to bring us together, and you're smart enough, your carrier, to find that right person and then see if it's agreeable to me.
right. So here's an important question. How do you arrive at your opening numbers at mediation?
Well, you do an awful lot of work is how you roundtable a case in the office, not just with the lawyers, but with staff. You do focus groups. You spend a lot of time thinking. I have one partner. You're talking to everybody about your case and what they think. One of my partners, Kevin Quinn, says he always does the elevator focus group. And I said, "What's that?" And he says, "I'll just turn to somebody in the elevator and say, 'What do you think about this?'" And so you're doing jury verdicts research. I mean, you're getting as much information as you can to find out the sweet spot for cases like this that will settle. And then you get as broad a spectrum as possible of input. And then you pick your number that feels right to you based on that.
What about one more important issue before we sort of wrap up? What if you have a policy limit demand situation and you're in mediation and you want to rely upon the fact that you've agreed to accept a policy limit and thereby open the lid on the policy? How do you deal with that? Because you have a confidentiality issue under the Cassell case.
Yeah.
How do you handle that?
After the mediation and outside of the mediation and mediation privilege, send the letter, the demand letter then, so that it's not protected by the mediation privilege. Sometimes you send it before the mediation and it becomes a leverage point during the mediation. But that can also apply to 998s that the defense wants to issue, and they might issue it to be timed to run right after the mediation, which brings some pressure during the mediation potentially. So there's a variety of strategy approaches on this, but if you want to demand the policy, I suggest that you consider doing it outside of the mediation. I don't know, Vince, what's your experience?
Typically, we'll send the demand for policy prior to ever going to the mediation. When I want people to come to the mediation, I want them to come with some sense of what I want, which is done that way through the demand letter. We also may put it in our mediation package, our brief to the mediator, saying we've already made a demand for the policy in here and we shouldn't waste our time unless they're thinking in those terms.
So let's take a couple questions in the few minutes we have from the panel outside. That is not a dinosaur on ice behind me. That's actually a whale and her calf in a cube of ocean. How important is the likability of the attorney to you guys?
Yeah.
What do you think?
From my perspective, I'm always thinking about the face, especially when I've got corporate defendants, the face of the corporation. You know, if I'm suing General Motors on a defective gas tank case, who's that lawyer that's going to put a face on General Motors? Yeah, so it's important. It's important.
Another question.
I agree 100%, David. I think it's very important. I always believe that you not only have to educate, but you have to entertain to some extent and to get your point across. And I think if you're a real curmudgeon, people just don't like curmudgeons. You know, they're going to respond accordingly. They're just plain everyday people that are there that don't really want to be there. And so they didn't come in to listen to somebody browbeat them or somebody to just be miserable and mean. So I think it's a very important point.
Let me try and get to a couple more questions. I'll combine a couple. Is there a disadvantage to being the party to suggest mediation? And is it beneficial to push mediation sometimes before depositions have been taken?
Again, each case depends on its own facts. I personally, I don't mind initiating the thought of mediation. I don't care if they think I'm weak or not by doing that, because my case is my case. I think I've established some credibility. I try not to take cases that are frivolous and meaningless. And so I don't mind at all initiating mediation. I don't care what they think. My case is my case.
Here's an interesting question. Third-party financing of litigation happens more frequently these days. Is the involvement of such financing likely to impact the mediation process? Any thoughts on that?
It's more of a plaintiff question, right?
Yeah. I'm stumped.
Oh.
They've asked a question I don't have an answer to.
Okay.
It's probably a factor the same as whatever is owed in the costs in the case, or I mean, you have to consider it all in your analysis of your case, but I don't know how that really impacts your work with the mediator and trying to get the case resolved.
Okay.
And chip in there.
Yep.
I mean, from the standpoint of ethics, it's my understanding that the financial backing on those type of arrangements must stay out of the case analysis. And so arguably it shouldn't affect anything at all. Vince hit it. If it's a cost incurred and it's a cost that has to be paid, you factor it into the value of the claim, you take it into account relative to liability and damages, and ultimately what's your risk at trial? Is it going to come out that way and cover that spread or not?
Here's another question. By mediator you trust, is Mr. Grebing indicated that there are mediators you should not trust with confidential information or provided in a separate mediation session?
Only those you've used once and found out.
Okay. And here's another one.
David,
Mhm.
on that question of the likability of the lawyers, I guess the acid test is, I'm just happy I don't have any cases against Charlie or Peter.
Okay, well, there you go. It says, let's see. This is a long question. As plaintiff's counsel go heavier on the obviously covered claims, insurance defense counsel obviously can't pressure the insured to contribute. However, would the mediator, when having a pre-mediation conference with both counsel, be out of bounds to suggest that defense counsel at least invite the insured to have their own attorney participate in the mediation? Very, very delicate subject. If you have a clear cumulus situation, likelihood is the parties have already figured it out and there's cumulus counsel. I have seen and I have asked sometimes is there anyone representing the insured specifically on the coverage question? You can't really tell them what to do. You don't want to get behind their lawyer. It's not the mediator's job to undercut the lawyer, so it's very tricky. You have to be careful. How important is it for both sides to meet the parties in person during the mediation process? This is a question we've talked about. In fact, judges usually used to have all the parties in the room in the beginning to make presentations. We're not doing that much anymore. What's your thought about that process?
Yeah, bad idea to have joint sessions. Again, not always, you never say always, because there might be a situation, but to start it off with a joint session, people tend to dig in, the parties are upset with each other. Why do that? It's unnecessary, and it just runs the risk of sending people back to their corners too quickly and without reasonable results.
Two more quick questions. Do you usually reveal to the mediator, and by the way, thank you for these good questions. Do you usually reveal to the mediator that you've used a focus group?
Again, every case is different. There may be a valid reason. I don't typically bring that up front to a mediator, but if in fact it's come out well on, say, a specific issue that's been is the subject area that's kind of the hang up for the mediation, for the settlement, I may well say, well, Judge, yeah, we laid it out to the focus group. I may even tell them, here's the exact question we asked the focus group, and we got 12 yeses. So again, it depends on the facts.
Can you give an example of evidence or information, e.g. smoking gun, that you would withhold during mediation and perhaps the reason for it? I'm assuming in all cases, this is something that's not obvious from discovery. They wouldn't necessarily find out on their own, and you don't want to reveal it until trial unless it's really going to settle the case. Is that a fair answer to that question?
And it depends in part on timing as well. If your mediation is early and you haven't done the discovery and you want to know exactly what the position is of a particular witness and or party, and you want that party to give deposition testimony that commits to whatever that position is, you might not want to give that away prior to the time that that event occurs.
Does there ever come a situation where you walk/leave a mediation? I think pretty much all of us would say yes to that. The other side's not being reasonable, nothing's happening, you don't want to waste your time. You paid for it. It's up to you whether you want to stay there, but do you all agree there are times when it's just kind of a waste of time to stay?
For sure.
Yes.
For sure.
Yep, absolutely.
All right, I think we're pretty much out of time. Any final thoughts anyone would like to add? Okay, well, thank you so much. As usual, you guys are brilliant, amazing, and I really appreciate your taking the time today to share what you know.
Yes, if I can chime in as well, thank you very much, gentlemen, and thank you to David for putting together this incredible panel. Thank you all for your generosity with your time and your expertise and these really interesting thoughts on mediation versus trial. To close us out this afternoon, thank you everybody for attending the program. As soon as you exit the Zoom, you will be directed to a brief survey. We would really appreciate if you take a couple of minutes to answer that survey and let us know how we did and provide any thoughts on maybe some future program or some feedback for our speakers today. In order to close us out, I would like to share a short video from ADR Services, Inc. And with that, thank you all for attending and have a great afternoon.
And here's my whale up close.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront, woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.